Determining Indian citizenship status requires tracking a specific intersection of birth dates, parental nationality, and subsequent legal amendments. A single date discrepancy can be the absolute difference between a valid claim and an illegal status. For legal consultants, immigration professionals, and civil service aspirants, guessing at these classifications is not an option. You need a precise, repeatable method for evaluation. We are going to build a 4-step diagnostic tool to definitively classify individuals as citizens, NRIs, or OCIs, and we will do this strictly according to the Citizenship Act of 1955. Applying this structured framework is the standard for avoiding classification errors that carry significant legal and professional consequences. Step 1 is establishing the constitutional baseline. India enforces a strict rule of single citizenship. It does not recognize dual allegiance under any circumstances. This baseline separates people into 2 distinct groups: citizens, who enjoy full political and civil rights, and aliens, who are subjects of some other state. As you can see in this text, the Constitution reserves specific protections solely for citizens. Most notably, Articles 15 and 16, which guarantee equality of opportunity and prohibit discrimination, are completely denied to aliens. Looking further up the page, the law divides aliens into friendly and enemy categories. Enemy aliens, subjects of countries at war with India, face even stricter limitations, specifically lacking protection against arrest and detention under Article 22. Verifying this baseline of single allegiance is your mandatory first filter. Only after confirming this can you move on to how citizenship is actually acquired. Step 2 is tracing the individual's profile against the 4 legal acquisition routes: birth, descent, registration, and naturalization. The most complex of these is citizenship by birth, which changes drastically depending on the timeline. The earliest rule is straightforward. Anyone born in India between January 26, 1950 and July 1, 1987 is a citizen by default, regardless of their parents' nationality. Then the law tightened. For those born between July 1987 and December 3, 2004, merely being born on Indian soil is not enough. At least one parent must be an Indian citizen at the time of birth. Finally, we reach the strictest tier. For anyone born on or after December 3, 2004, one parent must be a citizen, and the other absolutely cannot be an illegal migrant. If the child is born outside of India, they fall under acquisition by descent. The critical requirement here is that the parents must register the birth at an Indian consulate within 1 year. The remaining 2 pathways, registration and naturalization, are reserved for foreigners and persons of Indian origin. Both require long-term, proven, and continuous residency in India before an application can even be filed. By mapping your client's birth date against this timeline, you can instantly validate or invalidate their foundational claim to Indian citizenship. Step 3. Remember that Indian citizenship is not a permanent guarantee. You must verify that the subject hasn't triggered any of the loss clauses. The most common trigger is termination. Because India forbids dual allegiance, the exact moment an Indian citizen voluntarily acquires a foreign passport, their Indian citizenship is automatically voided. There is also renunciation, which is a formal, voluntary pathway where an individual of full age and capacity explicitly surrenders their Indian citizenship. Finally, we look at this text outlining deprivation. This is a severe, compulsory termination by the central government. As the clauses show, citizenship can be forcibly stripped if it was obtained by fraud or if the citizen has shown disloyalty, such as unlawfully trading with an enemy during a war. Evaluating a client means you have to prove a negative. It is not enough to show they acquired citizenship, you have to prove they never lost it. Step 4 is classifying individuals who live abroad or hold foreign passports into their correct overseas category. Let's start with the non-resident Indian, or NRI. An NRI is a fully legal Indian citizen holding an Indian passport, who simply happens to reside outside the country. They retain all their standard constitutional rights. This is entirely different from an overseas citizen of India. Despite the name, OCI is a lifelong visa. It is not dual citizenship because the individual holds a foreign passport. And to clear up a very common point of confusion, the old person of Indian origin, or PIO card scheme, is officially dead. As this provision notes, the government merged the PIO scheme directly into the OCI system back in 2015. So what does an OCI card actually do? It grants the holder specific practical benefits, primarily a multiple-entry, multi-purpose, lifelong visa to visit India, alongside broad economic and educational parity with NRIs. But there are absolute legal boundaries. OCI cardholders cannot vote, they cannot hold constitutional office, and they are strictly barred from purchasing agricultural land or plantation property. Misclassifying an NRI as an OCI, or vice versa, will lead to inaccurate legal advice regarding your client's property rights and tax obligations in India. So here is the complete diagnostic loop. Verify the constitutional baseline, trace the acquisition timeline, check for terminators, and finally, matrix the correct overseas status. This logic tree is the exact standard required to perform accurate legal, immigration, and civil service assessments without missing critical details. Now it's time to put this into practice. Click the link in the description to test your understanding against 3 real-world case studies.